Today, we're diving into three of the most explosive criminal cases in America: Harvey Weinstein, Alex Murdaugh, and Luigi Mangione. And the deeper question tying them all together is, can the American justice system still guarantee a fair trial in the age of social media, live streams, and podcasts, and nonstop public commentary? For example, Harvey Weinstein may now face a fourth trial after yet another deadlocked jury. Alex Murdaugh, his murder conviction collapsed after court clerk Becky Hill influenced jurors. She was immersed in that media frenzy surrounding the case, and she was even writing a book. And according to the judge, I love this one, who ordered a new trial, she had her fingers on the scales of justice. And of course, Luigi Mangione's prosecution has already, in my opinion, become a political flashpoint online before many potential jurors have even heard a single word of witness testimony. Now, the Constitution guarantees the right to a fair trial, but what happens when trials, stop being confined to the courtroom and become online content? So joining me today is Fordham criminal law professor Cheryl Bader, and now we're going to break down how media pressure, public narratives, and prosecutorial decision-making based on clicks are transforming modern criminal justice in ways the legal system was never designed to handle, in my opinion. So don't forget to subscribe, press the like button, and turn on notifications, because I am working on some great content for next week. So let's go ahead and we'll welcome our guest, Professor Cheryl Bader. Let me get her in the studio here. And welcome. Let's see. Hold on one second. If I can get you in and me out. All right, here we go. There we are. All right. Technical difficulties today. It must be almost a Friday or something. I don't know. So welcome to the Margaret McLean Show.
Hi, it's nice to be here. I'm glad I'm not the only one that experiences technical difficulties.
Yeah, I'm going to have to cut off that first part of the show, but I did come in twice, and therefore I heard an echo, but no echo anymore, and I won't do that again. So let's start with Luigi Mangione, and you're in New York. So what do you think? What is your take on that case so far? We just had a big ruling. If you want to start there, that would be awesome. So what did the judge recently do?
Yes. So just so everyone understands sort of how a case proceeds, right? So after arrest and arraignment, the prosecutor will turn over what they intend to present in discovery, and both sides will make any pretrial motions that they have before the trial. And what's called an omnibus motion, meaning it's an all-inclusive motion. So everything you want to argue to the judge, you put in those papers. And we saw motions to suppress evidence,
Yes.
and also motions to dismiss some of the counts. And so the judge had decided to dismiss the top count because there was a question of whether the prosecutor had overcharged, and when they charged murder in the first degree, that is a very sort of specific. People think, okay, an intentional, premeditated murder, that would be murder in the first degree. But actually, it's intentional murder is murder in the second degree, and murder in the first degree is murder if there are the extenuating, aggravating circumstances. And that could be things like, torture was used, or a police officer was the victim. And in this case, they were arguing that it involved an act of terrorism. And so here, the law says that the terrorism charge is one where, if someone did this crime with the intent to coerce the civilian population, right? To terrorize the population. And so here, the argument was, that's what Mangione was doing. And when I say, Mangione, because he's the one that's accused, of course, he is, presumed innocent at this point.
Right.
And so the judge threw that out, saying, look, maybe he was trying to terrorize, insurance companies or insurance executives, but that doesn't constitute the civilian population. Then there was the matter of what evidence will come in. And so we have constitutional rights, right? A Fourth Amendment right not to have, be subjected to unreasonable searches and seizures. And, everyone knows the, sort of Miranda case and the Miranda right that you have the right against self-incrimination. And so the judge was listening to everything that the police did in their investigation, right, before the arrest, to see if any of Mangione's constitutional rights were violated. And the judge did find that at the initial stage of the investigation in Pennsylvania, that rights were violated, and did say that certain evidence would not be admissible against him at trial. But much of the evidence the judge did allow in, especially very crucial evidence like the gun that was found in his backpack, and also the diary or journal that he had that included his sort of, what's being referred to as his manifesto. And so, much of the evidence did come in, but some was in fact excluded. And, not that I want to go into the weeds of a law school test, I'm happy to go over that if that's, something that you're interested in. But now, there's this exchange of evidence going on. When I say exchange, it's mostly from the prosecution to the defense. The defense has some obligations, but since the prosecution has the burden of proof beyond a reasonable doubt, most of those obligations are from the prosecution.
Right. And I don't think that, so I noticed across social media, of course, that people were saying, oh, it's a win for the defense, but I didn't see it that way. I felt that the prosecution has enough evidence to go on, and what was suppressed, I don't think will make much of a difference in the long run. Do you?
Right. I mean, look, I'm sure that the prosecution would be happy to have had, the magazine or his wallet, things like that. I guess the cell phone could be, somewhat important because it does give them the ability to, see certain things within his phone and track his activities. But they have a lot of that because they have his cloud, again, because I'm not so technically savvy exactly what it's called, but they are tracing his cloud account.
Join the club.
So they can track much of his internet searches, things like that. They even actually were able to find he went to a Best Buy and used a computer there, and again, because of the cloud account, they were able to track a lot of what he was looking at, communicating, and just where he was from different pings, things like that. So there's definitely enough evidence, and that gun and the journal, I think, were the most important things, and those were allowed in. And it's it's interesting because we, one of the things to sort of learn from this is, the police, when they were doing this investigation, right, they come upon him and they start to sort of talk to him. And in New York law, you're allowed to, the police officer is allowed to approach someone and just ask them like basic, simple questions without having, really much suspicion at all. And so, they started out, talking to him, but then, more officers came, et cetera. And then it became a more sort of coercive environment where he was, in custody, and an officer had moved the backpack. And so there's, various, laws and procedural rules around when you can search a closed container that someone has, like a bag, or a backpack, without a warrant, because we have a requirement, again, the Fourth Amendment right, that there be probable cause that there will be evidence found in that. And that has to be presented, and a judicial officer, as opposed to just the police officer, has to make that judgment. But there are various exceptions. And one exception is when you're, arresting someone, anything in their grab area that they could sort of grab and quickly, get at. For safety reasons, we allow the police officers to search. But because they moved that out of the way and it wasn't in the grab area and they didn't have a warrant and they started to search, but one officer then realized, I think we're on to something here. We've got this guy. We have to really be careful.
Yeah.
And they captured a discussion of like, well, can we say there was like, are we concerned about a bomb in there? Right? Like they're trying to, what are all the little exceptions, in the law that I want to trigger? And, so one officer said, you know what, we have to wait. Let's just stop searching the bag and bring it, to the precinct. And then they did what's called an inventory search.
Smart.
And yes, because there, right, in other words, it makes sense, right? That's also to protect the individual, right? If they have, and he had money on him, right? He had, right, you have certain things. And so it's to protect the police officers from any claim, but also to protect the person in their, theoretically, in their, in their effects. And when they're inventorying something, they could take it out. And even then, someone said, when we take out this journal, we're going to, take pictures of each page so that no one says, oh, we ripped out a page, we destroyed something, right? But we're just going to take the pictures and we'll wait for, to find out if we can like read them. So they were actually able to salvage those things. I should just mention also that because there's a parallel federal proceeding.
Yes.
And the federal judge did allow everything in. Okay. So because New York is a little stricter.
Yep.
And, has their own set of rules in addition to the Fourth Amendment, constitutional law that we see, in the federal court.
And could it also be the judge? Sometimes there's a difference in judges. That's why we have judge shopping. So do you think?
Absolutely. And this was a close case, right? I think they were really examining, what was said, who was standing where was the bag. It was very nuanced. And, as you could, look back and maybe, I don't know if you interviewed anyone before, I was sort of, asked some questions before the ruling came out. And, a lot of this was a close question and experts differed. And, ultimately the appellate court might rule differently. We've seen that in other cases, right? Where verdicts are overturned. They may say, you know what, this is they often will talk about what's called a fruit of the poisonous tree. Right.
Oh, yeah.
So in other words, if you think about like film, we don't really have film anymore, I guess maybe.
No.
But you think about a reel of film and you like take each little snapshot and you say, was there a violation here? Where was the violation? And the judge sort of pegged it at a certain spot. Right. But if you peg it a little earlier and then other things are fruit of that poisonous violation, you could see a different outcome.
Yeah, it all goes out. Yeah. And the law students love that. My law students, yours must too, the fruit of the poisonous tree. And I remember that from back in law school too. So, yeah. And what do you think about the appellate court here? What are your thoughts on, do you think they'll uphold the ruling? Do you know anything about the appellate court that will be hearing this on appeal?
Well, so in general, the appellate court is, fairly, I guess it depends on, sort of your perspective. And of course, the appellate court, there are 3 judges that sit and there were several judges. So you're not sure who are you going to draw. But one of the things is that when there's a hearing and there are credibility judgments made, right, an appellate court is usually not going to insert their own sort of decision and overstep sort of the court that is hearing, the judge that's hearing the evidence will make that, decision on credibility. And so, these officers, and, the judge did say, look, this whole thing about a bomb, if you were concerned about a bomb being there, they were like picking through, like, oh, there's this credit card here, they didn't
Yeah,
ask,
yeah.
and then they put the bag, and then after he said, look, let's take the bag to the precinct, they put the bag in the car with them.
Yeah,
And
exactly.
McDonald's was a lot of people around, so if they really thought there was a bomb in the bag, they didn't act like it. So,
Right.
there was some decisions made, concerning credibility, but, also finding, officers and the procedures that were followed otherwise to be, credible and to have integrity. And so, I think that will, make it less likely that a decision would be overturned on the evidence.
Yeah.
We'll see what happens with the, if there's assuming there's a conviction, right? If there's an acquittal, end of game, right?
Right.
Go back.
Right. Absolutely. And what about, I read one of your articles, or you were quoted in the New York Times about jury nullification on this case. What are your thoughts there in the long run? Is this a case that we could see jurors getting on the, being impaneled who have formed an opinion and may not say anything, but because they can't stand the insurance industry, maybe they had, a claim denied, or a parent had a claim denied and then they died. What do you think about that? Could we see that here?
So, of course, jury nullification is not an acceptable defense, right? So, in other words, the defense can't ask in a very obvious way for jury nullification, right? And the judge, of course, would never instruct the jury that they're allowed to. In fact, you might have an instruction otherwise, right? That they're not to let their sympathies, or feelings about insurance companies, et cetera. But, look, this has definitely captured the attention of the public. And there's a whole, free Luigi, and, people coming out and, Luigi from, the video game, Mario and Luigi, so there's certainly, I think we're seeing that anger against insurance companies, rising healthcare, costs, and the fact that claims are being denied and you can't get anybody on the, there's definitely a public frustration. But on the other hand, right, I mean, this was a victim who was, executed, right, in cold blood. And, I don't see jurors who are sitting in that courtroom and hearing, and the prosecutor's definitely going to humanize, right, this victim, his kids and his family. And so I think it'd be very difficult to see jurors decide they're going to, if they feel like the evidence is overwhelming and there's lots of evidence. And of course we have to see the prosecution's case and how it comes in, but to say, you know what, it's okay because we're really angry at insurance companies. So he's, it's okay. Right. I just don't see that happening. I mean, look, could there be a holdout juror that voir dire, the process of questioning jurors doesn't eliminate, and somebody who, turns this into a hung jury? Possibly, but again, in a long trial where jurors are, together and, going out, getting lunch, whatever, I just think that that's a stretch, but I do see the possibility of that coming in on I think the defense that probably is most likely to be pursued is not a complete affirmative defense, but what we call like a mitigation defense. So arguing instead that, if they, because they don't have to say he did it, right? But to say that if defense says, if you believe that this is what happened and that, he in fact is responsible for this homicide, that it is actually a manslaughter conviction that is in order. And they would argue that there is extreme emotional disturbance. That's a mitigation defense that the defense can put on, right? They have to actually put on evidence. It's their burden just by preponderance of the evidence, but it's their burden to bring on evidence to say that he was suffering from extreme emotional disturbance. And so I think that's where you might see like some, sort of sympathy or this kind of anger toward insurance companies as being, somewhat reasonable, right? And I use that, kind of, I feel like there's a little bit of a stretch because we're talking about a homicide, but the defense would have to establish that he actually was under this extreme emotional disturbance, and that it was reasonable under a reasonable person's standard in his shoes, right? So it's
Right.
it's a mostly objective reasonable person, but a reasonable person in the circumstances of Luigi Mangione, right?
Right.
And
Right.
so, again, there's going to be, big hurdles for the defense, because there's going to be, I'm sure the prosecutor is going to put on lots of testimony about how calm and deliberate, he was in his interaction with the, police, just in the whole process, and the sort of premeditation parts of it, to show that it wasn't this, sort of just extreme disturbance, or it wasn't in a disturbed state.
Right.
And then the question about the reasonableness as well, right? Now,
Right.
we may see, I mean, I don't know, but we may see, forensic psychologists testify, because, victims of trauma and people who are, experiencing, disturbed mental states, often will be either like disassociated, won't necessarily appear like, so,
Right.
I'm not sure if we're going to have like some battle of the experts there, or how they'll, try to get over those hurdles. But I think that's what we'll see from the defense.
Right. And I could see a lot of pretrial motions to suppress different experts too, in that case. Right.
Yeah, they'll probably want to have, like voir dire the experts to see what they're going to testify to. And, sometimes there can be arguments about whether, this really is scientifically accepted, right? But I think we've seen a trend toward understanding that, the brain is complicated, and there's a lot that, we, as lay people may not understand, and that, lawyers aren't the ones who should be kind of making these decisions, and that, we need experts to help us to understand more about, cognition and trauma and emotions. And so we've seen, I think, much more willingness for courts to entertain that testimony than we had, previously when I first became a lawyer.
Yeah. No, I agree. The state of mental health has changed too. People are more open, and it's really changed big time in that area. So, talking about jury nullification, just quickly, did you follow the Karen Reed trial here in Massachusetts? I'm in Massachusetts. You're in New York. Did you follow that at all?
A little bit. I know there was a lot of sort of media attention, and that there was sort of the kind of influencer culture and like kind of parallel proceedings going on in the media itself. And it was like, like team Karen. And so there was, I followed it to some extent. So, just seeing that, so the jury, right. So we don't know exactly, unless, you've read something that I haven't, we don't know exactly why the jury acquitted, right? I mean,
In the Karen Reed trial?
Yeah.
Well, there were two trials, and I
Well, the
followed
first
that
was a
one.
hung jury, right?
Yeah, the first one was a hung jury, but they after talking to some of the jurors, I believe it was something like 9 had voted in favor of guilt. So usually the second time around favors the prosecution, and Hank Brennan, who was the prosecutor, is amazing. He's normally a defense attorney, but he did a fabulous job in my opinion. However, the Free Karen Reed movement had become so big at that point, and the court, just around the courthouse, there had to be barriers, and people with pink shirts, and there were placards. So it was just something like I've never seen before. And I don't think from the get-go, no matter how well Hank had put that case in, based on that, the media frenzy, I don't think there was a chance for a conviction. Now, some people took it out in the police because they had Proctor, and some police officers that certainly were not good, had several evidence on their cell phones of, discriminatory practices and all that stuff. Not to get into it, but I thought there was a bit of jury nullification that went on there.
Yeah, and it's so that's the thing, is that it's very hard to know, right? I mean, one of the things is, look, sometimes jurors, especially in high profile cases, will want to talk to the media. Sometimes they feel like, oh, this is my moment, to be a celebrity. And so we do learn certain things. Judges often will caution and say, look, this was your deliberations were private deliberations, and sometimes I think jurors will, talk to each other about that and keeping, things private. But there've been some research, and I really, I kind of find it fascinating, and I just think there should be more research done on, what influences jurors. But as you were saying in the opening, right, there's a lot more. And not just, I would say, press, right? But, because of social media and, algorithmic amplification and influence culture, right? There's so much coming at people, and, you don't know you're going to be a juror. Like, well, neither one of us live in New York, so we won't be jurors in the Mangione case, but someone listening now might be.
My daughter might be. She lives in New York, Manhattan. So yeah.
So, she might be listening here and hearing what I have to say about evidence that was thrown out, right? And, so you can't unring a bell, right?
Right.
And so we don't know what, media coverage, and especially with, social media and TikTok and it being, kind of filtered, algorithmically, how that affects people, but also, as you point out, like the pressure, right? If you are hearing that there's a narrative that, that people are, a part of, or that there's even like a political aspect to it, right? Look, even with the Me Too movement, right? Some people want to convict or want it, right? So, these things, right? We're social beings, right? And we can't help but be affected. In fact, look, there's research that shows that, in terms of cognitive bias, that, once we sort of frame a narrative a certain way, or it's framed for us, that we look at it through that lens, right? And so there's a confirmation bias, right? There's an anchoring bias. There's all these, sort of ways that our brains function, that make us more receptive to certain arguments, and not others if we've already come in predisposed. And so and the pressure of knowing that this is that the public feels a certain way, right? Can't help but influence, but it's hard to know how much that influences one versus the judge's admonitions, being part of that courtroom setting, the solemn procedure, the judge telling you certain things, the camaraderie with your other jurors, and a way you look at also the lawyers, right? And how you're influenced by your how much you like a lawyer or feel similar to that person, right? There's so many dynamics that are psychological dynamics that are going on. It's hard to know which is trumps the other.
Right. So Mangione will most likely not be tried on there won't be cameras in the courtroom, right?
Right, that's correct.
Okay. So here in Massachusetts, we have cameras in the courtroom, and that's what we saw in Karen Reed. So I actually think, even though I like following the case gavel to gavel online and talking about it, and all these shows also do it, there is something to be said for New York's and the federal government's, federal courts as well. They don't allow cameras in the courtroom. I think there's something to be said for that, because people, I think I did read something where 46% of jurors will actually go back home and Google the case. So if they Googled Karen Reed, they're going to come up with all sorts of stuff. And there might, all it takes is one or two jurors to really watch it, The Lawyer You Know, or one of those cases, not cases, shows on the Karen Reed trial, and they may have been swayed a certain one way or the other. So
Right, and that might expose them to, the judge will release jurors from the courtroom to discuss things outside the presence of the jury. So you don't
Right.
want them then hearing that, and reading about it elsewhere, of course. And
Yeah.
look, it's so hard to know, and so much of our system is based on the integrity of jurors and whether they're following the instructions that the judge gives, not to look at outside evidence.
Yeah. I mean, times have changed from even 20 years ago, right? I mean, I think O.J. Simpson was one of the first trials that we had on TV. We were all watching that. Now, I would date myself here, but times have changed, and I do think it's very tempting, even though the judge every day will instruct jurors not to go home and Google or talk to people about the case. I'm just wondering how much that is followed, and if there's anything we can do about it, or the system can do about it to prevent that. Do we go back to sequestering jurors? I mean, that's expensive.
It's expensive. Jurors don't like it. I think you'll get people wanting, to get out of jury duty even more so. And especially for like a lengthy trial like this, it's just, it's very difficult to sequester jurors. But that, that is one way. The other is just, maybe having more sort of, lengthier. I mean, they've already become quite lengthy in these high profile cases, but, really trying to scrutinize, jurors a little bit more carefully, and directly about what what they're watching, what what social media they subscribe to. And
that's true.
How often, how much time they spend on social media a day, really, trying to learn a little bit more, and maybe talking to them more about the, kind of the legal process, and asking more questions about their philosophy on, impartial jury. So, but it's, I mean, this is a has always been a difficult situation when you have a high profile case. And of course, we've tried to move venues, things like that. But, now we're all exposed to, what's going on everywhere. Although, with cases that have a particular interest, for a particular community, sometimes venue can be helpful. Look, I remember when they, I was asked questions about, the Harvey Weinstein case when they were impaneling the jury, and they were talking about finding jurors who, don't know about the Harvey Weinstein case. And I said to myself, if you have somebody who says hey, I never heard of Harvey Weinstein, I don't think I'd believe them. But, if it were true, I would think, well, where's that juror been, and what kind of life are they living, and do I want them making important decisions? I don't know, so.
And of course, the issue is you can hear about it, but can you be open-minded and fair and impartial? So
exactly.
Yeah,
it used to be we thought about, an impartial juror. We would ask, do you always ask, do you know these people? Do you know anything about the case? Have you read anything, right? Those are questions that are often asked, because better to have a blank slate. But in these high profile cases, right, you're not going to get a blank slate. And so the question really becomes, is somebody, open to and capable of being open-minded and just hearing what happens in the courtroom. And we've seen, right, because jurors have been questioned afterward, that people will bring up in deliberation, well, but we all know this or that, and it's very hard, right, when you're making a decision to say, this is not, this is actually not a fact that we can consider if you believe it is a fact in life.
Yeah, no, that's a good point. Speaking of Harvey Weinstein, what do you think? Do you think the prosecutor will try it again?
So, it's a very tough decision. I would not, so many times I've thought to myself during his tenure, I would not want to be Alvin Bragg. He's had to make some very tough calls. But, it's a tough situation, especially when you have a verdict where, it was 9 for acquittal, right? To bring, the case again, because it is a costly case to bring, although less so than it, was at the outset. But on the other hand, right, if you are a prosecutor and you have a victim that has been, damaged and harmed, and that you feel is credible, that you want to vindicate that victim. And if that victim is willing to go through that again and to be cross-examined and to be exposed to the media, et cetera, it's hard to say to that person, you know what, we believe in you, but it's not worth it. Right. I'm not saying you can't say that, to say, look, here's how we see, look at, and that there's a risk that, there'll be an acquittal. And what will that, do you feel better about, the hung jury? Look, he's much older and frailer. He's already, he's convicted in the case in California, although that's, could be appealed, et cetera. But, I think it's a tough decision. And I do think also, it's not just this one victim, right? There's this aspect that, that Harvey Weinstein had harmed many people, that, because of the statute of limitations, they can't be vindicated at this point. And, just sort of, what it means in, for society. And I think there's a lesson in the Weinstein case, that even after the Me Too movement, and I think we've come, I don't want to say, a long way, baby, but, we've come a certain distance.
We have.
But you know what, there's still this feeling that, that old, rape myths still loom large, right? And what actually, and if you've had a consensual, relationship at some point, or you wrote, emails saying like, love you, et cetera, that means that you must have consented, right? We still don't understand completely the complexities around, consent and the social dynamics around, sexual relations, where there's a extreme power dynamic.
Oh, that's true. And I'm just wondering, were any of the jurors interviewed in the last case for Weinstein that you're aware of? I Googled it and didn't see it, but I could have missed it.
I hadn't seen that either.
Okay.
One of the interesting things is that, the Weinstein case, there was so much publicity during the first and even trial. And, it was like, I don't know what page it was on when, the verdict came out, but, there just was, I think I mentioned it to someone, and they're like, oh, really? Did that happen?
Yeah. By the time the
jury, okay. Right. And, everybody, had like, sort of turned their attention to, other
the
cases.
David Burke case.
Yeah.
That one out of LA is just great. So it's interesting because I see numbers.
Diddy was getting all these.
Yeah.
So, but Weinstein was like old news.
I know. Now, do you think that'll happen with Murdaugh? Like, people are saying, I mean, we've all watched the documentaries on Murdaugh, and it's hard to believe that one person, Becky Hill, the clerk of all people, forced a mistrial there with our fingers on the scales of justice. That's my favorite line. But do you think we'll have as much publicity the second time around?
I think there'll still be a lot of publicity the second time around. But yeah, it just goes to show you that here, there was, I think, overwhelming evidence, right?
Yeah.
And this would have been a very clean verdict, right? Had not.
Yeah.
And I remember I clerked for a judge when I first graduated from law school, and our courtroom deputy was the person who would like shepherd the jury, in and out, and like tell them like where they should get lunch and when they were deliberating, and he would bring the lunch in and everything, and just was like he was like the liaison, the person that the jurors like turn to, and so you have this kind of outsized like authority, right?
Oh, yeah.
And, and of course I think to myself, if he ever said like, oh, convict that guy, or that guy's lying, or I think that the jurors would certainly be influenced, right?
Yes, and
so,
and so it basically, when the Murdaugh decision came down, I read the memorandum on that, the judge's opinion, and there were several cases he pointed to where a court officer influence a jury by certain statements. So yeah, I was thinking about that as well.
Even like looking, I always think to myself, like, because again, when I would, sit in the courtroom and work for the judge, if you were to like roll your eyes, I mean, the judges, we have a courtroom deputy, we were the law clerks, you would like be poker faced, because if you were to like, make any comment or anything like that, right? Of course, that could have an influence. Interestingly, the trial judge didn't declare, didn't
Right.
the conviction, right? It was the appellate court.
You're right.
That reversed it and sent it back.
The pure per curiam decision. I misspoke there, but yeah, it was the appellate court. Absolutely. The trial judge probably said, I don't want to do this again.
Right. Right. Yeah. The trial judge was like, look, he, agreed that, that the clerk should not have done that, but said, because look, I guess there was overwhelming evidence, and, look, probably it wasn't like a but-for causation, but you can't, right? You can't, have, a clerk interfering with, with the jury process like that. And so therefore now, and of course, she ended up getting, probation and, having, taking a plea. And there was, some other things, I think was she, in perjury as well. But, that was an instance where I guess she was writing a book. Right. And so here you have people want to get in, right? And, sort of in on the whole media, action, and think, okay, I'm the clerk in this, high profile trial. I'm going to milk this. So.
Right. And by the way, I worked, going back a little bit, we had a high profile federal case here on Whitey Bulger a few years ago. You know who he is, right?
Yes.
He's the big Irish mob leader for years in New England. He's no longer with us, but he was convicted. But after that, there were at least 3 jurors on that case who wanted to write books. So it's kind of weird, So that's what I worry about, is jurors thinking, well, will a guilty verdict cause my book to, if I wrote a book on this, will I make more money if it's guilty or if it's not guilty? I don't know. That's what I worry about a little bit, is what type of, and I also noticed on the Karen Reed trial, one of the jurors became quite very involved in social media after the trial, and it still is. And, I think has her own show now and all that. So you gotta wonder about that. And she was very, very much in favor of a not guilty verdict from the get-go, and very vocal, the first juror to come out and be very vocal. And so people wondered if she had been following it all along on social media. But.
And you also don't know what the dynamic is and who the internal influencers are, right? Any dynamic, right? There's going to be those that are more outspoken and leaders and alliances formed and things like that. And we're not, sort of privy to any of that. But and if I remember correctly, this came up in one of the Trump trials.
Oh, yeah.
Where,
God.
the person who was writing books on, and so, yes, there was a question of whether this person, wanted to get on the jury to write a book. It's something some people will avoid, want to avoid jury service, and other people, like, they want to get on the jury.
I like getting on juries. I was on a federal jury, believe it or not, as a lawyer, and that it was during 2008, right after 2008, when big banks were bad, and of course, the bank denied somebody's mortgage, but the plaintiff had lied. It was a civil case, so there was a huge fight in the jury room. Ultimately, it was divided between liberals and conservatives, because a bunch of people said, hey, you know what? This is a big bank. So what? Give her the money. And ultimately, the jury found, we were deadlocked for a while, but ultimately the jury found in favor of the bank because the plaintiff lied on one of her applications. So, but it just, again, big fight in the jury. And I thought that was the most interesting experience I've had. Well, as far as being able to, a lawyer getting on a jury, was awesome. Have you been on one yet?
No, I haven't, and I really would like to be, because as I said, I'm so interested in the in the dynamics of the whole jury process. And I wonder now, when you talk about sort of political divisions. I mean, we're such a polarized society now, and so I wonder to what extent that infiltrates into the deliberation room. I know that the Mangione defense team brought up again concerns about sort of what was happening in the media, and trying to paint Mangione as this like radical liberal, and how that might influence things. So
I think the big defense firms talk about that. I think that's one of the strategies, is how to deal with the media prior to trial.
Oh, yes, absolutely. And, and the, judges will, they'll bring, attorneys will bring this up with judges, and then there's, questions around gag orders, things like that. And, but we're like balancing these two constitutional rights, right? So there's, the Sixth Amendment right to an impartial jury. And then there's the First Amendment right to freedom of the press and the open courtroom, et cetera. And so it's like there's this tension, and look, our First Amendment rights, we've always thought about these are really kind supreme rights, but think about also kind of due process, right, and having a fair trial. That the Fifth Amendment right, the Sixth Amendment right to a fair jury trial. That these are really important, especially when we're seeing a kind of a weaponization of the justice system. And so you want to make sure that the jury system is a fair system.
Right. And we actually just had a case here in Massachusetts, and of course I'm spacing on the case, but it was a case where the defendant chose, it would have been, it was pretty high profile here. Maybe not, you might not have heard about it, but it was a case where the defendant specifically chose a bench trial, thinking it would be better chance to get off. And they did get a liberal judge, and it worked, actually. They're not guilty. So
there are sometimes strategically where you think that your defense might not be as emotionally appealing, but might have a more legal appeal, right? And then you might think to yourself, maybe I'm better off with the judge's decision maker, or there's some complexities that might be difficult. It's these are hard decisions, and I think certainly in in high profile cases, we're going to usually tend to see more jury trials, but politics definitely can play into prosecutorial decisions. As you were mentioning at the at the beginning, I mean, we see that both in the, kind of the federal, in the Mangione case, the,
Mhm.
kind of the federal court, they were looking for this sort of, kind of death penalty
Yeah.
through charging, this, murder based on the, kind of predicate of the stalking, right, which remains
Yeah.
federal, the federal charge that remains. But murder is usually something that, state jurisdictions will deal with,
Right.
right? But
Right.
the federal court said, we want to be able to come in here and, federal prosecutors want to come in here and bring the death penalty, right? And
Right.
so kind
We're
of that
seeing that a lot more.
politics, right? Of like, we can show strength and we're, tough on crime and we're going to, impose the death penalty. And
Right.
so, but the judge dismissed that count because they found that the underlying predicate stalking charge doesn't necessarily have to be a violent crime, right? You can
Right.
stalk somebody in a non-violent way, and it can still be interstate stalking, right? And
Okay.
so throughout that charge, so now the death penalty doesn't apply there, and New York doesn't have the
Mhm.
death penalty,
Right.
and so the death penalty doesn't apply there. But
Right.
I could see, and then there's also
Yeah.
like who gets to go first, right?
Yes.
Which trial, which we also saw
God.
with with the Trump cases, which
Yeah.
who's going to get that first crack.
Yeah.
So there's politics certainly can enter into it, and look, I think in most jurisdictions, prosecutors are elected or at least appointed through a political process.
Mhm. Yes. Yes. Here they're elected. Well, the district attorneys. In New
Right.
York, they are too, right?
Yes.
Okay. And here, judges are appointed. So in New York, they're not elected, are they?
It's both. It's a weird.
Oh,
It's,
okay.
a lot of them are appointed, but there's also some that are elected.
And of course, getting the appointment can be political as
Yes,
well,
it
as
is.
we know.
Definitely,
So,
definitely.
well, you have been wonderful, and I really appreciate taking your time and this will live on my channel, and I'm gonna, of course, the very beginning, I'll shorten that a little bit where I had my echo, but it is, I thought you were very informative about, especially on that Mangione trial. So the listeners will really appreciate it.
Okay, well, stay tuned. We'll see what happens
Okay.
with the trial.
Absolutely. Well, thank you so much.
It's nice to be with you.
Yes, nice to be with you too. And I learned a lot. So hopefully you can come on again. I appreciate it.
All right, take care.
All right. You too, Cheryl.
Bye-bye.
Okay. Bye-bye. And again, thank you everyone for watching the Margaret McLean Show. Don't forget to subscribe and press that like button. Until next time.